if you have a glass of wine at a restaurant, you're not intoxicated and we're defending your life, are you liable for the glass of wine? And I think it raises a really interesting issue that comes up, and we see this from time to time. Let's say you, and I'm going to change Chuck's scenario just a little bit, but let's say you were, because when we were talking about intoxicated earlier, we were talking about defending yourself inside your house. Let's say you were intoxicated out in public. Do you lose your right to self-defense? And the answer is no. But where we find kind of an interesting caveat here in the law, and this you see this all over the place, is maybe it affects if your state has legal presumptions of reasonableness or duties to retreat or stand your ground laws. That's what we're talking about, because what we find over and over and over again is if you're committing a crime at the time that you act and use force or you use deadly force, then maybe you do have a legal duty to retreat. Maybe you don't get a legal presumption of reasonableness. And what is that? How does that affect when let's say this case ends up going to trial? How does that affect you in trial?
Yeah, that's a really, really good point. Let's say you're committing one of these offenses.
Yeah, you're committing a crime.
When you use deadly force. And this sounds really ticky-tacky and like a lot of legalese, but it is so important. Your jury is given a document.
Right.
Either immediately before or immediately after closing arguments, depending on what state you're in.
Yeah.
And that document instructs them on what the law is they have to apply to the facts of your case.
Yeah.
And it sounds silly. Like we watch these trials and we see closing arguments and we're like, oh no, they're making their decision based on the closing argument. When really that document is vital, which is why probably, I would say 90% plus of cases that get overturned on appeal are because of errors in that document, right? That's pretty much the only way to win an appeal,
right?
When you're a criminal defendant. And so, we have this situation where if you do everything right, you get your stand your ground, you get your presumptions, assuming you're in a state that has them. That document backs you up with that jury. That document is saying, you've got to presume Richard reasonable when he did this,
right.
Or you cannot consider whether or not Richard could have retreated. When that kind of language is absent from that document, you put the jury in a situation of, if they were listening to closing argument and said, I don't know, it's a toss-up.
Right.
They're not being instructed, right, to presume that you did the right thing, or to say, I don't like that he didn't retreat, but I'm not allowed to consider it, so he's not guilty.
Yeah, and I think the way that it comes up as a practical matter, it makes your job, and it makes your defense attorney's job much more difficult, because instead of starting off on the right side of the law or starting on the top of the hill and having the state having to disprove you or tear you down, you start off having to push the boulder uphill, persuade a jury that what you did was right. And so it makes a critically big difference.
Yeah. And the more self-defense cases we try, and we're running out of time, so I will keep this brief, but the more we see, I think that, we have this idea like, oh, I did the right thing. A jury will see that I did the right thing. No, your self-defense jury is tough because you've got anti-gun people, right? You've got neutral people, and you would think like, well, just pack my jury with the pro-gun people. The pro-gun people could be harder on you than all of them.
I'm sure there's people in the comments right now saying, don't drink and carry a gun. And they're going to be on your jury.
Is that, when we have juries and we're like, oh, that guy's a license holder, he owns guns, he told me all these great things during jury selection. And then they see the facts of the case and they're like,
I wouldn't have shot.
I wouldn't have shot. I wouldn't have done it that way. It's like, because they're very self-defense minded. So they're going to be even more judgmental of you than the people who don't even own guns. So
it's kind of surprising.
It is very surprising. But so that's why those jury instructions are so critically important, because it's tough to get a good self-defense jury.
Yeah,